A napkin contract is completely legal, and courts have enforced them for decades. Ever wonder why a scribble on a diner napkin can hold up better in court than a formal handshake? Today, I'll explain contract law like you're 5 years old. By the end, you'll know exactly what makes any agreement legally binding. And I'll cover the one mistake that can make even a 50-page document completely worthless. Quick note, this is legal education, not legal advice. If you're in a real situation, call a local attorney or legal aid hotline. Okay, let's start with a scenario. It's a Tuesday afternoon. You're at a diner with a friend who does landscaping. You've been complaining about your backyard for months. Dead grass, overgrown hedges, the whole disaster. He says he'll clean it up, redo everything, and maintain it through the summer. You say you'll pay him $2,000, and you shake on it. He pulls out a pen and grabs the paper napkin from under his coffee cup. He writes down the basics, the scope of the work, the timeline, the price, and both of you sign it. He starts the work, and 3 weeks in, the yard looks incredible. New sod, trimmed hedges, the whole transformation. Then you stop returning his calls and don't pay him. He shows up at your door and you say, and I'm paraphrasing, "That wasn't a real contract. You wrote it on a napkin, so I don't owe you anything." Here's the thing, you just made a very expensive mistake, because that napkin is actually a contract. He can take you to court with it, and he will probably win. So why does a napkin hold up when a handshake doesn't? To answer that, you need to understand what a contract actually is, because most people have no idea. A contract is not a document. It's an agreement. The document is just the evidence that the agreement happened. Think of it like a photo. The photo isn't the birthday party. The photo is just proof the birthday party occurred. Your napkin is the photo, and the deal you made, that's the party. For any agreement to be a legally binding contract, it needs 3 things. But here's where lawyers and normal people completely talk past each other. None of these 3 things require a printer, a notary, or a lawyer. Lawyers call them offer, acceptance, and consideration. Offer is simple. One person says, "Here's what I'll do, here's what I want in return." Your landscaper friend said he'd redo the yard for $2,000. That's the offer. Acceptance is also simple. The other person says yes. You said yes. Done. Consideration is the one people get confused by. It sounds fancy. It's not. Consideration just means both sides are giving something. He gives labor and expertise, you give money. Both sides are trading something of value. That's it. No consideration, no contract. But in this case, you both have skin in the game. Worth noting, consideration doesn't have to be equal. Courts generally won't weigh whether you got a fair deal. They just need to see that something was exchanged on both sides. Offer, acceptance, consideration. A napkin with those 3 things, signed by both parties, is a contract. A 50-page document missing one of them? Not a contract. The judge doesn't weigh the paper. The judge reads what it says. Now here's where it gets interesting, and slightly infuriating. Most people assume there's a 4th rule hiding somewhere, like the contract has to be typed, or notarized, or drafted by a lawyer, or printed on official paper. There is no 4th rule. Courts have enforced contracts written on napkins, cocktail receipts, sticky notes, paper bags, and the back of business cards. One case involved a deal scrawled on a Post-it note. It settled for over $1 million. Let that one sit for a second. A Post-it note. 7 cents of yellow paper. Legally binding. The law doesn't care about the medium. It cares about the meaning. But wait, there's a twist. And this is the one that actually catches people off guard. While most contracts don't have a format requirement, some contracts have to be in writing to be enforceable at all. It's a rule called the Statute of Frauds, which sounds dramatic and honestly kind of is. Certain deals are so big or so serious that courts decided a napkin isn't enough. We're talking about contracts for real estate, contracts tied to marriage, agreements that take longer than a year to complete, debts over a certain amount depending on your state. In some states, that threshold is as low as $500. So this rule reaches further than most people expect. Here's the version that could actually hurt you. Your neighbor tells you he wants to sell you the strip of land between your properties. You shake on it. You even write it down on a piece of paper at the kitchen table. He takes your deposit. Then he changes his mind and sells it to someone else. You try to enforce the deal. And the court says, and this is the infuriating part, that's not a valid contract for land. You needed more. Specifically, you needed a properly executed written agreement that describes the property with enough detail to identify it. Completely legal. Also completely enraging. Also completely avoidable if you'd known about the statute of frauds before you handed over that check. Here's what makes this worse. Your neighbor isn't confused about the law. He knows exactly what he's doing. He's betting that you panic, take the loss, and move on before you figure out that a proper written deed could have locked him in completely. That's not a miscommunication. That's a strategy. So now you know what makes a contract real, and you know the one category where the napkin breaks down. But there's one more layer, because knowing a napkin can be a contract is useful. But recognizing when someone is using a contract against you, that's the actual superpower. Here's what that looks like. Your employer calls you into a meeting. HR slides a piece of paper across the table. The email you got this morning said, "We'd like to review your current agreement and sign an update." What the paper actually says, in very corporate language, is this: "Please sign away your right to sue us in court, agree to arbitration only, and release any claims you currently have." Thanks, HR. That's a contract. A real one, with consideration. Maybe a small bonus, a title change, something. And the moment you sign it, it's enforceable. Studies have shown that most employees spend less than 5 minutes reviewing documents HR asks them to sign. The napkin at the diner and the document in the HR office have more in common than most people realize. They're both just agreements with evidence attached. The only difference is one of them is harder to read. What makes the HR version dangerous isn't the language. It's that most people don't recognize it as a contract moment. They think a contract looks official, important, laminated maybe, so they sign because it feels like paperwork, not a deal. But paperwork is a deal. That's the whole point. Knowing that changes how you read anything someone asks you to sign. Because the law doesn't care if you understood it. It doesn't care if you felt rushed. It cares that you signed it. That's it. So, your landscaper takes you to small claims court. He brings the napkin, both signatures, a clear service, a price, work completed. You argue the napkin isn't valid. The judge checks the 3 elements. Present, checks the statute of frauds. Doesn't apply. This isn't real estate. Work was performed. The agreement is enforceable. You owe $2,000 plus court fees. You lost. Over a napkin. Over a piece of paper that cost nothing and said everything the law needed to hear. Here's the clip line. A napkin isn't a joke in court. It's evidence. And the next time someone asks you to sign something, anything, over lunch, in an office, at a kitchen table, you now know exactly what's happening. An agreement, in writing, with consideration on both sides, is a contract. Doesn't matter if it's typed, notarized, laminated, or scrawled on a coffee-stained napkin at 2 in the afternoon. And the next time you make a deal, write it down. Doesn't have to be long, doesn't have to be fancy, just needs the 3 things. Because a simple napkin you wrote yourself is worth more in court than a handshake you can't prove happened. Drop a comment. Have you ever had someone try to back out of an agreement because it wasn't official? What happened? And did you know at the time that you might have had more legal ground than you thought?